Okay, everyone, thank you so much for attending our webinar today entitled Restitution and Homicide, a Crime Victim's Right to Prompt Restitution. My name is Laura Cook, and I'm the Director of Training and Technical Assistance with the National Center for Victims of Crime. As Juan just said, if you have a question, you can go ahead and type it in the box in the bottom right-hand corner there, and if you don't see that box, there should be a couple buttons toward the bottom of your screen. There's a little chat bubble, and if you click that bubble, the box should pop up. So thank you for joining us, and special thanks to our presenters, Dan Levey and Randall Udelman. Dan Levey currently serves as a victim advocate and program manager of the Arizona Crime Victim Rights Law Group. Dan was previously the executive director of the National Organization of Parents of Murdered Children, and he also previously served as the director of the Office of Victim Services at the Office of the Arizona Attorney General and as an advisor for victims to the Arizona governor. Dan has been a dedicated advocate for crime victims' rights since 1996 when his brother Howard was murdered. His focus has been to change and improve public policy concerning the treatment of crime victims and their families, and he has been involved in crafting numerous pieces of victims' rights legislation. Our other presenter is Randall Udelman. Randall is a private practice attorney with Udelman Law Firm, PLC. He's also the president of a victim rights attorney for the Arizona Crime Victim Rights Law Group. He's a member of the National Alliance of Victims' Rights Attorneys, NAVRA, which is NCVLI's Bar Association, and has previously been a member of the National Crime Victim Bar Association, the American Association for Justice, the Insurance Bad Faith Litigation Group, and the Arizona Association for Justice. Randall was the recipient of the 2017 Arizona Attorney General's Office's Distinguished Service Award for Leadership in Victim Rights. So thank you both again for offering your time and expertise to us here today. And with that, I'll turn it over to you for the presentation.
Thank you. Dan? Dan? Dan, are you there? Dan, I think we're having a technical issue on our end.
It seems like Dan's sound might be disconnected.
Hey, Dan, if you can hear us, you might want to hang up the phone and dial back in or try to reload.
While Dan is calling back, I want to thank everyone for joining the webinar today. And just real briefly, I'm going to try and give a background. My name is Randall Udelman. I'm the victim rights attorney for the Arizona Crime Victim Rights Law Group. We are pleased to be a part of this process today, and I appreciate having the opportunity to talk through some issues that are near and dear to us because we see them on the ground pretty much every day. Establishing amounts of restitution and collecting on restitution are the topics that we're hoping to briefly touch on. The topics are certainly very they can get very complicated, and we certainly hope to just touch on these issues today and at least give a flavor for the types of issues that you can be on the lookout for as you are in your practice. Dan, are you back with us?
Yeah, can you hear me?
Yes.
Okay. I just want to make sure, and sorry about that technical glitch. And I will just follow up with what Randy was saying, as it's an honor for both of us to present. It's an important issue and one that is often overlooked in homicide cases. And so we hope you come away with today's presentation with some new information and some new tools to help in this area. The first thing I want to mention is OVC's Vision 21, which was Transforming Victim Services in their final report, which I thought was telling and very profound, that it included all crime victims in the 21st century can readily access a continuum of evidence-based services and support that will allow them to begin physical, emotional, and financial recovery. And as Randy mentioned, this is an area that we've developed an expertise in and have assisted prosecutors and judges and others in understanding some of the tools in the toolbox that we have and that may be available to you in your state. So I just wanted to highlight the importance of financial recovery. Some of the common reactions, and I just put this slide in there to kind of, I know all of you know, having worked with homicide survivors and families, that you know common reactions. But I think, and in my own experience, as Laura said, my brother was murdered in a gang violence homicide. He was a random victim and shot and carjacked. And so in the aftermath of that, we, like all survivors, are thrust into the criminal justice system. And it really is important, the work that you all do, because I distinctly remember the advocates that really saved my life and were there and provided me with the tools to be able to go on and to advocate for my family and for my brother. But the focus for survivors is typically on once they apprehend somebody, there's a big focus on punishment and accountability, and that's understandable. Shock, anger, disbelief, the feeling that the murderer, if found, may have rights and protections, and survivors of homicide have few rights. In my work at the governor's office, the attorney general's, parents of murdered children, and in my work now, both Randy and I have worked with many homicide surviving family members / victims. I use that term interchangeably. And so you may be asking yourselves, why us? Why are we hearing this presentation? Because so much is going on in victims' lives, and prosecutors are focused, understandably, on presenting the case if they make an arrest and if it's being prosecuted. And you're providing service to homicide, and so we look at this as another tool in the toolbox to help bring this various issues and concerns about restitution up to the victim or up to the prosecutor or a victim's rights attorney if you're working with one of those. It's often overlooked in a complex homicide, but it's something that, and many people think, and probably rightly so, that the perpetrator is going away forever. We don't want their money and let them go to prison, and that's certainly understandable, and many survivors feel that way. But I think when you can attach another piece of accountability and responsibility to the offender, it's something for some victims that's important that perpetrator know every week that they're paying restitution and that it's not going to go away. And you have a role as an advocate for restitution at sentencing or even after sentencing if new losses come up. And we'll touch on some of those, but things like post-traumatic stress disorder, counseling services that maybe weren't ordered initially at the time of sentencing, and other losses that may not have been thought about at the time of sentencing or may not have been needed at the time of sentencing. And so with things like appeals and death penalty and other things, it's, as you guys know, it's not a 1-hour TV show or a book with a beginning and an end, but victims endure this incredible journey, and different things might strike their emotions and the need for assistance. But first you need to understand what restitution is and how it works. It helps hold the murderers accountable, even beyond the incarceration, which, of course, I think for many is the primary function of incarceration. It's also a monthly reminder of the horrible crimes they committed. I've worked with families that and in my own brother's case, where it was a therapeutic benefit to know that, it was one less bag of chips or one less thing the inmate could buy, and that would have to go to restitution. And we just, in our case, donated it to an organization. But and it's a carrot to encourage prisoner accountability. Although they may never get out, or they are getting out, at some point they need to learn that there's huge consequences for their action, and part of that is restitution, along with the punishment and, I guess, other rehabilitation tools that they may learn. Each state has their own statutory definition of restitution and economic loss. So what we're going to go over today, some of it is focused on our state, but we tried to give a national view as well. And these may be things that you can go and look in your state to see if you have certain tools that we have here, and if not, be the catalyst for legislative change, which is what we've done. We saw things in the law that needed to be changed, and we did that. The term restitution in the criminal justice system means basically payment by an offender to the victim of the harm caused by the offender. Each state, as I said, has their own statutory definition. Restitution in homicide cases covers things like prescription charges. I don't know if you can move it to the next one, Randy.
Yeah, I just did. Yeah, I did.
Counseling costs, expenses related to participation in the criminal justice process, travel, child care expenses, future lost wages, insurance deductibles, crime scene cleanup. We recently had a case where one of the victims had a young child and was concerned about bringing the infant to court. They wouldn't allow the infant into court, so trying to find babysitting resources to watch the baby would be something even that would be considered as economic loss as a result of the crime. It covers in a homicide funeral expenses, which include burial, mortuary, hearse, headstone and flowers, chapel music, honorarium, and you can see the others there on the screen. In homicide cases, restitution is typically ordered, but what we've learned and research is that in 1/3 of the states, courts are required to order restitution to victims in cases involving certain crimes, typically violent offenses, which of course homicide is, but other serious offenses as well. I guess we're lucky in Arizona that we're one of those states that have good restitution tools. But I can tell you that before Randy and I started doing this work, much of the legislation and enforcement of restitution was already on the books, but effectively nobody was using what I call the tools in the toolbox. And so it's important to know as advocates, prosecutors, what you have available and what can be asked or what the victim can ask for. And I'll turn it over to Randy for the next section.
Thank you. And by the way, at any time in any part of this presentation, if you have some questions, apparently you have an opportunity to type them out, and we'll try and stop the presentation and get to those questions if need be. I want to back up a second and just talk a little bit about the fact that there are certain types of economic losses that are a bit more challenging than others in order to identify and seek an award of restitution. I'm going to use Arizona as an example of what economic loss is. Arizona defines economic loss, which is subject to an award of restitution, as a loss incurred by a person as a result of the commission of an offense. It includes lost interest, lost earnings, and other losses that would not have been incurred but for the offense. What economic loss, and by way of extension, restitution does not include is losses to the defendant, damages for pain and suffering, punitive damages, or consequential damages. Now, it's important to understand that there are certain things like lost wages when we are looking at this particular presentation and talking about losses in restitution and homicide cases, some people would ask the question, well, are economic losses for lost wages, are they lost wages to the surviving victim, or are they lost wages to the person who passed away as a result of the offense? That question I answer is both. You, as a crime victim, a surviving victim, have the right to recover lost wages that it takes to go to and from court, away from the office. If there is trauma that requires somebody to take time off of work or FMLA leave, the lost wage definition includes that time. But there's also federal law and Arizona law that talks about the lost earnings and earning capacity of the person who lost their life. And that case law, as long as a victim attorney or a prosecutor can show by a preponderance that there was economic loss, that it would not have occurred but for the crime, and that the criminal conduct was directly, not consequentially, the cause of the economic loss, then both federal and state law would include the calculations of lost income. Oftentimes it's a challenge to put those numbers together. You would need an economist, an expert. Lost earning capacity, though, is an area of loss. Even when the victim dies and the family is seeking lost income for the victim. There are issues that I can get into the weeds on a little bit further. How you develop that, typically you would need an economist to look at the earnings history, education levels, and compare to some life expectancy, work-life expectancy tables, and come up with a dollar amount in a lump sum over the next, whether it's 20, 30, 40 years, and then take another step and discount that amount to present value. Those types of issues, if you wanted to get into the weeds a little bit more, we can do that offline, or I can answer follow-up questions. But typically, developing future lost income is I think, an important element of economic losses in a homicide case. And don't overlook that. There are cases out there, in particular, there's a 10th Circuit federal court case that found that economic losses resulting from the homicide of an infant child, the future anticipated lost wages are recoverable, even though the losses are for an infant. And as long as there's expert support on the range of those types of lost income, they are recoverable. The courts have struggled on the question of consumption versus non-consumption deductions, but for purposes of this presentation today, I can just say that lost income is an essential element of economic loss. States define economic loss a little bit differently. For example, under California, there are, in addition to lost wages, lost profits, property loss, there can be some non-economic losses on certain types of crimes. Also, I think I ignored a discussion about victim attorney's fees. Probate attorney's fees, for example, if a victim had to engage a probate lawyer to close out an estate, or there was an insurance issue, those types of fees that a victim had to spend money on are recoverable. There's a question about how you get an economist to help determine future lost income on a case. I would think you do need an economist in general. There are economists throughout the state that at least we in Arizona use, and we always attempt to either work with economists that are willing to provide their services at no cost or low cost. Initially, to answer your question, I think it's important in order to develop lost wage claims to have some type of expert assistance. Where you find that, perhaps you can reach out to us and we could try and help where needed, or we could certainly work with some partners in other states and try and answer the question who would be able to provide expert assistance and at no cost. But
I'll just add in, Randy, that I don't think it's beyond the scope of the prosecutor's office, perhaps, not in every case, but perhaps being able to, like they do with other expert witnesses, cover that cost. But yeah, we do try and find people that will do it for free or very low cost.
So, a good point, Dan, and that's very good. So, working with your prosecutor's office initially, and if that doesn't work, then reaching out and seeing if there's expert assistance. But I don't believe a court would be able to assess loss without some expert assistance, unless that loss is so clear cut that that it would be beyond. Well, I can't say beyond a reasonable doubt, unless the losses are so clear. And I can't envision a scenario where that would be the case. I would strongly encourage any practitioner who is going to look at lost wages to have an expert assist them. Non-economic losses, I think we already talked a little bit about. Those are not covered as restitution eligible. Pain and suffering is not subject to restitution awards in the criminal case. Certainly if there's a collateral civil case, that's a different issue. There's some cases in Arizona in particular talking about attorney's fees incurred by separate attorney to act as an adjunct prosecutor. Well, those are not covered. Punitive damages that are not designed to make the victim whole, but instead designed to punish are not covered. Consequential damages, both federal and state law, really suggest that there has to be a direct and reasonably foreseeable link between what the economic loss is that you're claiming and the crime. I'll give you a quick example of a case where an elderly gentleman ran an oil well in Louisiana, and he's in Arizona, and he was a victim of an aggravated assault. He was hospitalized for several weeks, and while he was hospitalized, he was supposed to travel and service oil wells in his oil wells in Louisiana. Well, while he was in the hospital, there was some vandalism that occurred at his oil wells because there was nobody on site. That type of expense, some $10,000 in vandalism cost, would not necessarily be considered a foreseeable or direct loss. It would be considered more consequential. The further away the connection is between the loss and the crime, the more difficult it is to establish why it should be subject to restitution. Also, there's a 2018 U.S. Supreme Court case that came out, Lagos versus United States, that talks about this particular case involved a General Electric that hired some forensic accountants to learn about and investigate some fraud and fraudulent schemes crimes that were going on. The court in that case said those types of expenses incurred during participation in investigation or prosecution of the offense are not recoverable as economic loss. I'm disappointed in that outcome, but I think that there are expenses, if asked by the government to incur those types of expenses, perhaps they might be considered as economic loss. But once you have a dollar amount awarded for restitution, what happens next? It's you get a piece of paper that says, congratulations, you have an award. But what we like to see is what happens after that. At least in Arizona, the court in Arizona needs to identify an amount of restitution as well as the manner of payment. And courts allow victim input in that process. We try and look at creative sources of recovery of restitution. Once the court determines the amount, if it's at sentencing and there's a bond, for example, and if that bond has been posted by the defendant, there's one source of potential recovery in and of itself. Before a bond is exonerated or goes back to the defendant, we try and make sure that we determine the amount of restitution, and we ask the court, if at all possible, to exonerate and release the bond to help either partially or fully satisfy the restitution obligations to the victim. That's just one source of potential areas of recovery of restitution. In other areas, at least in terms of taking steps when you have a restitution award, if the restitution has been reduced to either a restitution lien, in Arizona it's automatic if we ask for, I'm sorry, it's not automatic, it's what we have to do in Arizona is either take the restitution award and reduce it to a restitution lien, or we request the judge to issue a criminal restitution order. But either of those scenarios, the only difference between a lien and an order is interest on the restitution. Once we get a lien or an order, we record those liens with the county recorder's office, with the Department of Motor Vehicles, and with our Secretary of State's office. And those liens automatically attach to property owned by the defendant. And we've had cases where we get a lien and a defendant stops paying on their house and a foreclosure action happens. Excess proceeds after payment of mortgage are subject to a restitution lien. And that's one issue that we always encourage people to take restitution awards and record them and perfect those liens if at all possible. The difference I mentioned between a restitution lien and a criminal restitution order, at least in Arizona, is we have the ability, if a judge orders it, to earn interest on unpaid portions of the lien amounts, the unpaid portions of the restitution order amounts, whereas a lien does not.
And yeah, I'd just add in that in the case Randy's talking about, where we put a lien on excess proceeds, the defendant hasn't been convicted yet, and the lien simply tolls that money, if you will, and it doesn't go back to the murderer. In the case that we've done it in, it was a gentleman that allegedly, although he's in custody, killed his wife in front of their children, and amazingly, he stopped paying his mortgage when he was in jail. It's a capital case. And so, like Randy said, once the house foreclosed and excess proceeds were going to go to him, the court awarded a restitution lien to freeze those monies. And once he's convicted, that will go to the victim for the restitution. So it's just areas that you may not think of, but there are opportunities.
There's a question about whether human trafficking cases have mandatory restitution requirements, and the answer is yes. Under 18 U.S.C. Section 1593, there is a mandatory restitution obligation for human trafficking and slavery, and the restitution is it's for the full amount of the victim's losses, and include the greater of the income or value to the defendant of the victim's services or labor is guaranteed under minimum wage and overtime laws. So I hope that answers the question that was brought up in the comments. In terms of the manner of payment, when an award has been made and the judge is considering what amount to order as payment, a court has to consider, and typically it's through probation services or a probation officer that's writing a pre-sentence report, typically the court has to consider all assets and income. And in Arizona, it includes a consideration of workers' comp benefits and Social Security benefits. The problem with considering Social Security benefits is it may be considered, but it's not subject to a levy or attachment or garnishment or other legal process. So in other words, if somebody's only receiving Social Security benefits, there has to be some other inquiries in terms of if they have other abilities to pay. A defendant has an obligation when there's a restitution award to at least make a good faith effort to find money to pay restitution. And a victim has an opportunity to, if they disagree with whatever manner of payment is awarded by a court, our jurisdiction allows a victim to file a petition and request a hearing and get more details about why the court ordered a certain amount of payment every month. Now, when you collect on restitution, there's kind of a few key points to consider. First time period for restitution is whether if a defendant is in jail, incarcerated at the Department of Corrections, or not. Our jurisdiction, if a defendant's incarcerated, there's inmate spendable accounts that victim has a right to deductions from those inmate spendable accounts. So if somebody's in prison and they're earning a job at in the prison laundry and they're having family members deposit money into an account of theirs, Arizona says between 20 and 50% of whatever those earnings and monies that come into their inmate spendable accounts are, that money will be withdrawn from their spendable accounts and must be forwarded to the clerk of the court to pay victims restitution. It's not just earnings, it's any family contributions, anything that comes in to an inmate spendable account. Under federal law, I think I talked a little bit about recording criminal restitution order or a restitution lien. Federal law allows the same type of lien procedure and even a foreclosure action once a lien has been recorded appropriately. And under Texas law, I try to come up with some other state examples. Under Texas law, you enforce a restitution order in the same way as you would a civil judgment. So if you had an opportunity to sit down and conduct a debtor's exam, for example, find out what assets and liabilities and income a defendant has, you can do that under Texas law. Arizona law allows you to pursue other civil remedies, but you have to file a separate civil lawsuit to do it. Arizona and Maryland, as some examples, allow tax intercepts also. If somebody has state tax refunds, they're allowed to be intercepted once the criminal restitution order or once an award is issued by a court. The defendant also, once they're released from prison, if they go on parole or if they're in probation, our jurisdiction has an obligation that probation officers now have. It's a new law. The probation officers have to keep an eye on the defendant's monthly payment of restitution obligations. If they keep paying appropriately, they don't need to take any further action. But if they stop paying their appropriately awarded restitution, or if they pay in an amount that isn't what was originally ordered, and if they do that, if they ignore that obligation for a minimum of 4 months, the probation officers in our jurisdiction need to notify the judge that's assigned to oversee this case and explain reasons for non-payment, expected length of non-payment, and recommendations for further action, if any. One of the recommendations for non-payment or further action for non-payment is potentially holding a defendant in contempt. The probation department if they're going to oversee, as they oversee the payment history, also if they report to the court, they have to provide notice to the victim and to the prosecutor. And the victim and prosecutor can certainly request a hearing at that time.
I was just going to double back a little bit on restitution when they're incarcerated, the defendant or the inmate. And we changed the law here in Arizona to make it 20 to 50% of what their mail money or work earnings are, because previously, and it may be in your state, where only 30% of their earnings would be paid to restitution. So, for example, if they're earning, 50 cents an hour, 15 cents would go towards, restitution. And so when the law was changed probably at least 10 years ago, it allowed more meaningful collection of restitution, because if their gang buddies are sending in money or who are family members, it captures that. And so look in your states. If there isn't that type of statute, California has it, some other states do. We'd be happy to share with you what we've done here. And it increased the collection of restitution enormously. We didn't track it as far as murders alone, but even if you're in lockdown or solitary confinement or on death row, you're still paying restitution, because that money, if you get any money in your inmate account, or if you're working, obviously on death row you wouldn't be, but they have people, all kinds of people that send them money. So it's just an area to see and make sure you have meaningful collection of restitution while incarcerated.
Thanks, Dan. If a defendant's on probation, a victim still can consider filing a petition in our jurisdiction asking a court to hold the defendant in contempt. And if it appears that there's a willful non-payment of restitution, or I think important language in our jurisdiction is if the defendant were to make an intentional refusal to make a good faith effort to find money to pay restitution, they can be held in contempt. And contempt could include any number of options as a remedy. Some options would include a garnishment. Option could be sending the defendant to jail for a short period of time with what's called a purge order, requiring them to come up with a certain lump sum payment to get out of jail. Typically what I see is, and I think what Dan sees, is the courts saying, we will issue a writ of garnishment for your employer. It would be a difficult challenge to send a defendant who doesn't pay any restitution to jail if that amount of time is something that is not substantial amount of time. If a defendant doesn't pay their restitution obligations for several years, if they turn a blind eye to consistent demands for payment in some amount, a court would be more likely to find a willful or an intentional refusal to make good faith efforts and may send a defendant to prison or to jail, with a purge order. Once a defendant is released from prison, if an order, I think I talked about the distinction between a restitution lien and a restitution order in our jurisdiction. Once a defendant has been released from prison, our jurisdiction says a criminal restitution order for any unpaid amounts is automatic. And at that point, if it wasn't done at sentencing, that criminal restitution order starts earning interest on the unpaid balance in the annual amount of 10% a year in our jurisdiction. But you also have to take that next step I talked about earlier, and that's filing the criminal restitution order with the county recorder, so there's a lien on real property. Department of Motor Vehicles in our jurisdiction, so there's a lien on autos. And then any other separate or personal property, filing a lien with the Secretary of State's office. At least in Texas, there are civil discovery tools that don't necessarily require court permission. So you can actually seek some discovery tools, formal, what they call interrogatories or requests for documents, or a debtor's exam to find out what the defendant's expenses, assets, and income are. Arizona, we actually have to get some permission from a judge first, and that's our law at least allows us to at least request, and some judges do it and some judges don't, information, or request the opportunity to seek information about the defendant's financial capabilities before we ask the court to consider a contempt petition. The type of discovery that you would want to consider are details about income and assets, employment, family support. Is there any equity in a home? Is there a homestead exemption that might limit what equity there is in the home? Is there cash value in an insurance policy? What are their expenses? And we see situations arise where if a defendant is doing their NFL pay TV package at the expense of paying their restitution obligations, courts don't necessarily take too kindly to that. The crime victim in our jurisdiction actually has a constitutional right to receive prompt payment of restitution, and as a result, prioritizing a pay TV package is looked on a little disfavorably. But typically, you want to look at basic obligations that a defendant has.
Randy, I think a good question to ask would be, or at least to inform people, that do you need an attorney to do all this, or a prosecutor, or victims on their own can just take some of these steps that we've been talking about?
Yeah, no, that's I think you'll see that some of these steps are probably helpful to have a lawyer involved. It seems as though, at least in our jurisdiction, there are forms available through the clerk of the court's office that allows some of these requests, but understanding them is a little bit difficult when a crime victim who never asked to be a part of the criminal justice system in the first place is going to have to sit a defendant down and ask questions about income and assets when they don't want to see this person in the first place. It makes for a very challenging ability to recover restitution under those circumstances. So I certainly recommend that victims seek out an attorney to help in the process. Federal government has the U.S. Attorney's Office that would provide assistance, although we act as counsel to help in those situations also in federal court. But certainly when it comes to recovery of restitution, if somebody's not getting regular payments from a defendant, it helps to have a lawyer assert remedies on their behalf. Thanks for asking that question, Dan. Typically, if we were to look into and receive information about assets and income, we would want to at least attempt to negotiate some type of plan with the defendant that includes a consequence for non-payment, that requires judicial oversight, that requires additional late fees if there is non-compliance, and if there's any update in employment history or address, we would want to know that and have an affirmative obligation that the defendant who's off probation, for example, would provide that information as promptly as possible. And then to the extent, I think I misspelled the word waiver, sorry about that. To the extent that there's non-compliance, we would typically want to build in a waiver of process service requirement if we were to request a hearing. And the hearing that we would request is in the form of a contempt request hearing. In order to show cause regarding contempt is our jurisdiction's approach to how to handle non-payment issues with the criminal defendant who's off probation. And I think I mentioned earlier, one remedy is also a writ of garnishment of earnings, property, or earnings. One question that's come up in the past is whether an attorney or a victim has to comply with the Fair Debt Collection Practices Act to recover restitution, because it sure sounds like some of the stuff that I've been talking about is more like a debt collector than anything else. And the answer is no. Restitution obligations are not considered debt, and they're considered damage obligations thrust on a defendant as a result of criminal conduct. So my analysis is that there's certainly not an obligation, as I see it, that enforcement of restitution and restitution collection efforts are not subject to the Fair Debt Collection Practices Act. And the reason why I say that, the Act itself imposes some obligations on debt collectors. You have to say that this information is an attempt to collect a debt. There's some magic language that the federal act requires, and I just don't think it's necessary to comply with that based on the case law that I've seen. There's a question about whether NCVC's Crime Victim Bar can help families find pro bono attorneys who can help families with seeking restitution or with handling non-payment issues. Thank you for that question. I'm going to leave that to NCVC. I think the answer is yes. And at the end of this presentation, we'll have our contact information as well. We do work in Arizona. We do work out of Arizona also, and other jurisdictions, at least around the Southwest. And we can also assist folks in finding practitioners in other jurisdictions to the extent necessary. Thank you for that question, and I'm sure NCVC representatives can also answer that question.
Yeah, sure, Randall. This is Laura. Thanks for the question, Mary. I appreciate it. The National Crime Victim Bar Association may be able to help with some of these types of cases. The one distinction I do want to make is that they aren't, it's not a resource for pro bono attorneys. It's a resource for attorneys who are typically looking at filing civil lawsuits for victims of crime, including victims of homicide. We have a lot of attorneys doing wrongful death cases and a lot of attorneys who are really, really knowledgeable about those types of cases. Typically, if somebody's helping with a wrongful death case, they're going to be able to help with restitution and any other types of things that are involved in that case, making sure the victim's rights are being enforced throughout any sort of criminal procedure and things like that. But it's not a pro bono resource per se. So it's probably going to be dependent upon the circumstances whether we could refer somebody to an attorney for this type of issue. It really would depend on what that person is looking for specifically.
And thank you, Laura. It's kind of ironic. I went to the slide that talked about civil remedies.
There you go.
At the end of this presentation, our contact information is there, and we can certainly try and help folks if they need pro bono assistance also. To the extent that we can do it on our end, we're happy to at least try and find some referral sources. But I think with respect to potential for civil remedies, clearly we're going to talk about that right now. Once a defendant has been charged and convicted and imprisoned, our jurisdiction in the federal mandatory, I think it's the CVRA, I think Crime Victim Rights Act, I believe has a provision in there. If it's not that, it's the Mandatory Victim Restitution Act, says that a defendant cannot deny the essential elements of what has already been, what they've already been convicted on. And so it's a principle, it's called collateral estoppel. Defendant is estopped from challenging the essential allegations of the criminal offense in a separate civil action. That's a powerful tool. But at least in our jurisdiction, you also have to take it a step further. We talked about economic losses earlier. You cannot double recover for economic losses in a separate civil proceeding. On the other hand, we talked about general damages. That's not restitution eligible. Pain and suffering and punitive damages and other consequential damages. Those are not recoverable in restitution, so they may be recoverable in a separate civil action. And the good news is in a separate civil action, they don't have to necessarily relitigate the essential allegations that have been made and charged and proved up. in the criminal case. They don't need to do that again. The only questions typically on a civil case that involves the same type of conduct is what the level of damages are for general pain and suffering and punitive damages. Also, keep in mind, civil judgments potentially, and I say potentially, it depends on the nature of the civil allegations, but they are potentially dischargeable in a bankruptcy action, and there are some potential insurance coverage issues that could be helpful. Whether there's a homeowner's insurance policy, some insurance policies contain intentional acts exclusions and might not provide coverage, but some do. Auto insurance, same thing. Umbrella policies are typically more broad in scope and may actually provide some coverage for an intentional act that might not under the homeowners itself. And then there's also business or commercial liability insurance. Those types of insurance policies typically would provide some employee theft-related coverage and some other types of intentional coverage, but they do have limits. And then there's also corporate director or officer or fiduciary liability types of insurance. We know that restitution awards and orders are non-dischargeable in bankruptcy. Some civil judgments, if they include allegations of willful conduct, would not be dischargeable in bankruptcy either. But just be real careful, and I would certainly advise you to get some attorney advice on whether a civil claim would be considered dischargeable or non-dischargeable in bankruptcy. I'm going to turn it back over to Dan for a moment so that he can talk about the role of system-based victims and victim witness advocates.
Thanks. The role of the victim witness advocate who's system-based, certainly they have many, many important responsibilities and are an important asset to victims. In the area of restitution, part of what they can look for, and usually, not in the initial stages, but certainly as time goes on and it lingers through the criminal process, advocating for the victim's restitution to the prosecutor. Sometimes prosecutors aren't thinking about the restitution or maybe aren't aware of some of the things you've learned today. And again, as Randy said, our information is going to be at the end of the presentation, but we offered up that we would provide, technical assistance and help try and find lawyers in your area if we needed to, in addition to other resources like NCVLI and the National Center for Victims of Crime, of course. Work with the victim in collecting documentation of the losses and remind victims to keep receipts and a logbook for mileage if they can. Those all are important and all go towards restitution. Go to court with the victim to restitution hearings. In our experience, a lot of times, the case is over with, the person's been sent to prison, so there may be supplemental restitution hearings to try and establish the restitution loss, and I think it's helpful to have an advocate there with the victim, or even if the victim's not there, to go and be able to report back on what happened. Obtaining restitution information from victims and provide alternative means for the victim to be compensated for damages incurred as a result of criminal behavior. Obviously, things like victim compensation, which plays a key role. But if victim comp, only pays, like in our state, up to $25,000, and the restitution may go way beyond that, that's something that is eligible for restitution. And so there are other sources for the victim to be in the civil process, as we talked about. And a lot of times it's just mentioning it to victims so that they know about it. The role of the nonprofit community-based victim advocate, obviously work closely with the victim, same thing, to keep receipts and records, contact the prosecutor and advocate for the victim, to ask any questions about what may or may not be covered. and suggest and see in your states what's involved in filing a restitution lien, which Randy had talked about. One thing we have in Arizona is the ability for a victim on their own to ask for a pre-conviction restitution lien before the defendant is convicted, and that would preserve any assets before they sell. And I would think or hope most states have restitution liens, and again, we can help you if you need legislative ideas. The role of the prosecutor in getting restitution ordered, as we see, prosecutors, as we all know, represent the state or the federal government, not the victim. And so the victim is really responsible for presenting the restitution amount to the court, but so is the prosecutor, and that's ultimately their job, is for the prosecutors to present it to the court and lay it out and have it all documented in a ledger so that the court can understand and defense counsel can understand as well. Prosecutors should find out if restitution is important to victims so they can be prepared to request it as part of any sentence, especially in plea deals. Oftentimes, restitution is part of a plea deal, and they agree to stipulate to pay whatever, $100,000 in restitution, but it's not always something that the prosecutor will be aware of. So they need to know, is this something that's important to the victim, and if it is in a plea deal, to impress upon the court the importance of restitution and the defendant complying with that. And as I mentioned, they must document their losses to the court in the form of expert testimony, such as getting an economist or somebody else, somebody that could testify about what the victim earned at their employment if it can't be proved through other ways.
And I'd just add a couple of things, if you don't mind.
Sure.
Typically, when it comes to a restitution hearing or an enforcement hearing, I see at least attorneys for the victim taking the lead on those hearings and the prosecutor acting more as the adjunct under those circumstances, because the prosecutor represents the state. And the victim issues that come up in connection with establishing the amount of restitution, a victim has the right to ask the prosecutor to present that information. And if they don't have counsel, they can do that. I just think under normal circumstances, if there's a way to get a victim attorney involved and take the lead on presenting evidence to establish the amount of restitution, it benefits the victim to do that. And do it in a way that protects the victim, their privacy, and ensures that the full amount of the actual economic loss is identified and presented to the court. And also present a full hearing that would lead a judge to consider whether in an enforcement action the defendant has actually willfully refused to make a good faith effort to find money to pay restitution. We see this benefit to have a private victim counsel involved in the process, and it certainly helps. And I would venture a guess to say that if you compare cases that have private counsel with cases where prosecutors are representing the state only or the federal government only, I would think that the collection numbers are probably higher when private counsel's involved. Thank you. Dan, did you want to?
Yeah, we just listed some, on this slide, some resources for restitution, and you can see them there on the screen. But even though we're Arizona-based on criminal restitution matters, we provide training and technical assistance to other jurisdictions and do get calls and offer up our advice and try and work to the extent we can with those agencies. The National Center for Victims of Crime, I know Laura put a message up of their contact information, and the National Crime Victim Bar Association, I believe that's what Laura posted, National Crime Victim Law Institute, National Organization for Victim Assistance. And if you have in your state a law clinic or somebody that provides pro bono, as Randy said, it can be very helpful. That's all I had. Randy, I don't know if you have any wrap-up or if there's questions.
I think we mentioned at the middle point of the presentation that if anyone had any follow-up questions or ever needed help finding counsel that does nonprofit work of this type, here's our contact information, our email, our address. Really appreciate having had the opportunity to present today. Hopefully you found it somewhat insightful, and I think we have hopefully enough time if there are any follow-up questions. I guess I'll see if, I guess now's a good time then to turn it back over to the NCVC staff folks if there's no other questions. Again, thank you so much for the opportunity to have presented today. Hopefully you found it helpful.
Yeah, thank you, Dan and Randy. We really, really appreciate your expertise. I frankly learned a lot. This is a lot of stuff that I really didn't even know, so I really appreciate the in-depth look on restitution. If people have questions, you can type them there in the bottom right-hand corner in your chat box, and we'll wait a couple minutes for any other questions that might pop up. All right. Well, yeah, you guys, everybody who attended, thank you so much for attending. You guys can go ahead and log off if you would like. Oh, we did get one question popping up. He mentioned incarceration as a way to motivate offenders who are not paying restitution. Are there any other ways to motivate those who are not paying restitution?
Thank you for the question. Typically, I would suggest that if the offender is not paying but is employed, one tool would be a writ of garnishment against their particular income, and we would have to receive approval from the court to issue a writ of garnishment, but that's one other tool. If the person has real estate property and they have equity in a home, another tool would be to initiate foreclosure proceedings, or at least attempt to initiate foreclosure proceedings as a tool to incentivize a defendant to sit down and come up with a manner of payment or catch up on payments that haven't been made. You can't necessarily do that with motor vehicles, but if somebody were to attempt to sell a car, it's subject to a lien. But those are at least some of the other ways: garnishment action, potential foreclosure. I would ask a court to have this person sit down for a examination under oath, and then ask the judge if it looks bad, if they truly have not made payments, and if you can establish a track record of willful ignorance of the effort or the obligation to pay restitution, I would say ask the court to put him in jail.
Yeah, you could.
Yeah, I'm sorry. There's a good question about restitution. The defendant would have to sell the car before proceeds would be applicable to pay restitution. I'm not aware of a procedure where a court has given the authority to a victim to seize an asset like a car before, in order, as a consequence of non-payment of restitution, or as a consequence of contempt. Perhaps that might be an option that we might want to try, but I just haven't seen a court that has approved that. Thank you for that question. It would be the defendant that would have to sell the car first.
And they wouldn't be able to transfer it to their wife or somebody else. It preserves that asset to go to the victims. And one other incentive, which Randy touched on, for offenders to pay other than incarceration is just finding them and bringing them back to court, because a lot of offenders, in our experience, they think they're done with the process and the criminal justice system, and the idea that they're going to have to go back to court, potentially be put in jail for not paying their restitution, that tends to motivate people. We have a judge that he recently retired, but Judge Steinley, that would hold a restitution court where, he would lay out that if you don't start paying your restitution, you're going to wind up in jail. And so just finding common allies and champions that are willing to work and maybe go outside the box.
Okay, well, thank you so much again, Dan, Randy, for sharing with us, and thank you to our attendees. And we'll let you guys go. Have a great weekend.
Okay. Thank you.
Thank you so much.
Bye.
Okay, well, I'm going to end the webinar.